Let's unpack this. Today, we're taking a deep dive into Europe's fascinating and really rapidly evolving AI landscape.
It certainly is moving fast.
Yeah, think of it as exploring two sides of the same coin. You've got this rigorous control, but also this bold government-led growth. Our source for this deep dive is the July 2025 issue of Diritto Intelligente. It's a prominent AI law journal from DLA Piper. Our mission: to cut through all the complexity, find the most important nuggets of knowledge, and help you understand the urgent developments, the strategic visions, and the practical implications of all this AI regulation and innovation for organizations, for individuals, really.
And that urgent need for understanding, you can really feel it, can't you? We're not just talking theory anymore.
Yeah.
Key legal deadlines are coming up fast, and we're already seeing foundational legal cases emerge. Cases that will set precedents for, well, years to come. This is hitting operations, procurement, strategy right now. And for anyone involved with AI, knowing what's coming is, frankly, absolutely critical.
It's clear the theoretical chat is over. This is
Mhm.
impacting businesses now. July 2025, it really marks a turning point, doesn't it? Especially with the EU AI Act starting its phased application.
Exactly.
And the spotlight, I gather, is on one of its maybe the most crucial and contentious elements: the actual definition of high-risk AI systems.
That's the core of it, yes.
It's like once you label something high risk, suddenly there's this whole new world of obligations opening up.
Precisely. The AI Act takes a risk-based approach. It classifies AI systems into four distinct categories. You have unacceptable risk systems. Those are prohibited outright. Then you have high risk, limited risk, and minimal risk systems. And it's those high risk systems that face they're really tough obligations because they're seen as having the biggest potential for harm.
Okay, so what makes something high risk then?
Two main things, basically. Either the AI system acts as a safety component in a product that's already regulated under EU law, like medical devices, critical infrastructure, that sort of thing. That's Article 6.1 and Annex 1. Or the system poses significant risks to people's health, safety, or their fundamental rights in really sensitive areas like education, employment, law enforcement, access to public services. That's Article 6.2 and Annex 3.
That sounds incredibly complex. I mean, for a smaller company, how do they even begin to figure out if their existing AI tools might unknowingly fall into this high-risk category without, a massive legal team?
It's a huge challenge, definitely, which is why the Act demands pretty detailed compliance measures for these systems. We're talking about robust risk management frameworks, significant transparency obligations, mandatory human oversight,
Right.
and thorough conformity assessments before they can even be placed on the market.
So like getting a car safety certified before it hits the road.
Kind of like that, yeah. But for AI,
Yeah.
it's a big hurdle.
Okay. And digging deeper into the practical side, there was a crucial public consultation on this high-risk AI definition, right? It just wrapped up June 6th to July 18th, 2025.
That's right.
Here's where it gets really interesting. Who should have been involved in that, and why was it so vital?
Well, the consultation's main purpose was to get feedback to inform the upcoming guidelines. These guidelines will give practical examples of what is and what isn't high-risk AI. They're due by February 2nd, 2026. The target audience was pretty broad: AI system providers, deployers, the companies using the AI industry bodies, public authorities, academics, civil society groups, everyone with a stake, really.
And why was their input so critical?
It was crucial for them to provide real-life scenarios, actual examples from their work. This helps shape the guidelines so they're practical, not just theoretical, and hopefully avoid rules that are maybe disproportionate or impossible to implement. The stakes here are incredibly high. If your AI system gets classified as high risk, it has to meet these comprehensive standards: data governance, data quality, human oversight, transparency, robustness, accuracy, cybersecurity. It's a long list. For the providers, this means putting in place proper quality management systems. For the deployers, the users, it means monitoring how it's used and being transparent with people affected by it. So this consultation, it was a rare chance for everyone involved to actually influence the scope, maybe clarify how it interacts with other EU rules, and basically shape future enforcement, get more legal certainty.
Okay, so connecting this back to the immediate compliance reality.
Right.
What does this all mean for businesses today? What's the blueprint for navigating this right now?
The most immediate thing is that AI Act compliance deadline, August 2nd, 2025. That's just around the corner.
Right.
On that date, a critical group of obligations become legally binding, meaning suddenly a whole new set of rules will actually have teeth.
Okay, like what specifically?
Well, things like the designation of the authorities who will actually oversee and enforce this for high-risk AI. specific requirements for providers of general-purpose AI, or GPAI. I think the big foundational models like ChatGPT that power lots of different applications.
Ah, so the big model providers too.
Yes. Also, foundational AI governance rules kick in. Penalties become applicable, though, with some exceptions for GPI model providers initially, and new confidentiality obligations related to post-market monitoring.
So it's not just the big AI developers in Silicon Valley or wherever who are affected. This hits closer to home for regular businesses too.
Absolutely not just the developers. This represents a really clear shift from what used to be maybe soft law or best practices to actual enforceable obligations.
Yeah.
It impacts developers, providers, yes, but crucially also deployers.
Deployers, so any company that integrates or just uses an AI system in their work.
Pretty much. Even, say, a marketing agency using an off-the-shelf generative AI tool for writing copy could potentially face these new audit powers down the line. Regulators are going to have significant audit and investigation powers. Ignoring this really isn't an option.
Okay, that definitely makes the need for a structured approach to AI governance even more pressing. What does that look like for businesses trying to get their house in order?
Right, a robust governance model is essential. It really needs several key components. You can think of it breaking down into maybe three core areas: strategy, operations, and continuous improvement.
Strategy, operations, improvement. Got it.
So first, under strategy, you absolutely need strategic oversight from the top. Leadership has to define how the organization uses AI, guided by principles like trust, risk minimization, and then translate that vision into actual internal policies. And that flows down into internal governance committees. These need to be multidisciplinary teams. You need legal, compliance, cybersecurity, data governance, IT all working together. They evaluate risk, oversee specific use cases, manage vendor relationships.
So it's that top-down direction combined with cross-functional teams actually doing the work.
Exactly. Then, moving to the operational side, a huge piece is mapping and classifying AI use cases.
Finding all the AI hiding in the business.
Precisely. Many everyday tools, automated HR platforms, credit scoring systems, they qualify as AI under the Act's broad definition. And lots of them might unknowingly fall under high risk. You have to identify every AI system being used and classify it correctly. Following that, you need AI Act compliance policies, developing the internal rules, verifying they actually meet the Act's requirements, ensuring all your processes line up. You have to operationalize compliance across different departments.
And for those systems you do identify as high risk, what about the specific controls?
That's really the core of the operational aspect: risk management and controls. Once you've mapped them, these AI systems need robust controls. Things like human oversight, explainability mechanisms, bias detection and mitigation, ensuring they're resilient, proper security protocols, and holding your vendors accountable. For high-risk AI, remember, these are now legal requirements, not just nice-to-haves or best practices.
Makes sense. And the third area, continuous improvement.
Yes, continuous improvement. Because AI isn't static, right? You need continuous monitoring. That means revalidating systems when the software or data changes, keeping track of legal updates because the landscape will keep changing, revisiting your risk assessments periodically, and crucially, documenting this entire process. You need an audit trail for compliance.
It sounds like a lot, but it makes sense.
It is a significant effort, but this strategic approach offers real value. Reduced exposure to fines, obviously, but also improved operational efficiency, increased trust from stakeholders, customers. And it makes you prepared for emerging global AI regulation standards, too. It's really about building a future-proof AI strategy.
It's fascinating to see how stringent the regulatory side is becoming. But if we connect this to the bigger picture, Europe also has this much broader strategic vision for AI, right? Showing the growth side of that coin we mentioned.
Absolutely. Back in April 2025, the European Commission adopted the AI Continent Action Plan. Its aim isn't just to regulate, it's actually to position the EU right at the forefront of global AI development,
Okay.
leveraging its research excellence, its industry, its skilled workforce, but crucially, rooting all that development in ethical, trustworthy, and interoperable technology.
So Europe's bid for digital sovereignty and AI.
That's a great way to put it. Ensuring it controls its own AI destiny rather than just relying on, say, global tech giants. It's really ambitious.
That's a powerful ambition. So what are the pillars? I think there were 5 strategic pillars designed to boost the EU's digital capacities by 2030. How are they going to achieve this?
Right, 5 pillars. The first one is all about building a large-scale AI computing infrastructure, basically giving European AI developers the horsepower they need.
More computing power.
A lot more. This means creating 13 AI factories across member states by 2026. These build on the existing Euro-HPC supercomputing network. So if you're a startup or an SME in Europe or even a researcher, you'll get unprecedented access to serious computing power and technical support to develop your own AI. It's about democratizing advanced AI development.
AI factories. I like the sound of that.
Yeah, and alongside those, there'll be up to 5 AI gigafactories, specifically for training the really big generative AI models at scale. Funding-wise, this is backed by Invest AI, which is expected to mobilize over 20 billion euros.
No.
And this pillar also includes the new Cloud and AI Development Act that's about fostering private investment, emphasizing green data centers, and aiming to triple the EU's data center capacity in the next 5 to 7 years.
Okay, so building the muscle for European AI innovation. What about the fuel? The data those systems will need?
Good question. That leads directly to the second pillar, ensuring access to high-quality data. This involves the data union strategy, which aims to create a single, unified European data market. Easier sharing, easier access. The AI factories will also have data labs built in. Their job is collecting, structuring, harmonizing data sets so they're interoperable while making sure they comply with ethical standards and data protection rules, of course. The overall goal is to simplify the rules for data access, sharing, and reuse, essentially treating data as a kind of European public good.
Makes sense. You need data for AI. Pillar 3.
Pillar 3 is promoting AI in strategic sectors. Right now, the uptake is pretty low. Only about 13.5% of European companies use AI solutions.
That seems low.
It is. So the Commission is launching this Apply AI strategy to try and reverse that trend. The focus is on key areas: industry, public administration, healthcare, scientific research, and the AI factories, plus the European Digital Innovation Hubs, the EDIH.
Ah, yes, the local support centers.
Exactly. Those EDIH will help make sure these AI tools and resources are accessible, especially for SMEs, the smaller players who might otherwise get left behind.
And the human element. You need people to build and manage all this AI, right?
Absolutely. That's the fourth pillar, developing AI skills and talent. This involves creating an AI skills academy, offering EU-funded scholarships, PhD programs, international mobility opportunities, especially focused on generative AI. It also means specialized university degrees and professional development courses, with a strong emphasis on reskilling and upskilling workers, particularly in manufacturing, SMEs, and other sectors that maybe haven't digitized as quickly.
Okay, infrastructure, data, adoption, skills. What's the fifth pillar?
The fifth pillar ties it all back together, facilitating the implementation of the AI Act. By summer 2025, so very soon, the Commission plans to set up the AI Act Service Desk.
A help desk.
Yes. Exactly. An operational help desk providing both legal and technical assistance. They'll give tailored advice on compliance, setting up internal processes, how to label systems correctly, managing algorithmic risk, basically practical help for businesses navigating the new rules.
That sounds incredibly useful.
It should be. This whole action plan, all 5 pillars, it's really a decisive step toward that European technological sovereignty in AI, building an integrated ecosystem that's ethical, competitive, and, well, European. Europe really taking its AI destiny into its own hands.
Okay, so we've covered the big regulation and the grand strategy. Now, let's pivot to a different but equally vital aspect of AI intellectual property and the fascinating challenges it presents. This feels like a particularly thorny issue.
It really is. We're talking about the very first preliminary reference to the Court of Justice of the European Union, the CJEU, that specifically concerns generative AI and copyright. This is the case of, like, Company versus Google Ireland, C2505. It originated in Hungary. And the implications here, they're potentially enormous for creators, for AI developers, for everyone, really.
Okay, the first big case. Can you give us the background on that dispute? What actually sparked this significant legal battle?
Certainly. So the dispute started with an article. It was published on a Hungarian website, balatonkornyiki.u2r, by a company called Like Company. The article was about a Hungarian singer, Kuso, and his alleged plan to release dolphins into Lake Balaton. Bit of an odd story.
Dolphins in Lake Balaton. Okay.
Yeah. Anyway, the article is about 579 words, unsigned, and apparently compiled from various online sources. Now, Like Company claims that Google's Gemini chatbot, their generative AI, was prompted to summarize this specific article in Hungarian. And they say the chatbot generated a detailed summary of the original content.
Ah, so the AI summarized their article.
Exactly. And Like Company argued this was copyright infringement. They also claimed it was an unauthorized communication to the public under the EU's Digital Single Market Directive, the DSM directive.
And Google's response?
Google, naturally, denied any infringement. They argued, first, that no reproduction actually occurred in Hungary, so Hungarian law didn't apply. They also claimed the summary wasn't a reproduction or a public communication, arguing it didn't reach a new public and was just presenting factual info, not copying the creative expression verbatim. And furthermore, Google said, even if it was deemed a reproduction, it should fall under existing copyright exceptions, like temporary copies allowed under the InfoSoc directive, or, crucially, the text and data mining TDM exception under the DSM directive.
TDM text and data mining, that seems key here.
It's absolutely central to the case.
So what were the critical questions the Hungarian court decided to send up to the CJEU in Luxembourg? These questions are going to shape the future, aren't they?
They absolutely will. The Budapest District Court referred three really crucial questions. First, can a chatbot's response, when it reproduces identical content from a protected publication, be considered, legally speaking, one, a reproduction, and/or two, a communication to the public? And importantly, does a chatbot's internal predictive process, how it actually generates the response, matter legally?
Okay, that's fundamental. What's the second question?
Second, does the actual training of an AI model, specifically when it uses copyrighted material during that training phase, trigger the author's reproduction right? So is the training itself potentially an infringement?
Huge question for AI developers. And the third?
Third, if training does trigger the reproduction right, then does the text and data mining TDM exception, specifically Article 4 of the DSM directive, apply to shield that training activity from liability?
Wow. Those are massive questions. What kind of things will the CJEU have to consider?
Well, several key things. They'll need to look at whether the original article content itself is actually protected by copyright. Remember, mere facts aren't protected. It has to be original expression. Then there's the huge technical challenge of proving derivation in these complex large language models, the LLMs. It's really hard to show a specific output came directly from a specific input due to the opacity of the training data. How do you prove it copied?
Right. The black box problem.
Exactly. Also, the CJEU has historically emphasized a very high level of intellectual property protection in Europe, which might lean towards protecting creators more strongly. However, there's a strong counter-argument, saying that using copyrighted data for TDM during training automatically triggers the reproduction right and isn't covered by the TDM exception could undermine the whole reason the EU created TDM exceptions in the first place, which was specifically to facilitate research and innovation, including AI development.
So it's a real balancing act.
It is. And it's also important that TDM is only one part of how AI models are trained. There's no explicit EU exception for AI training as such.
So when can we expect an answer?
Don't hold your breath. A final decision probably isn't expected before late 2026, maybe even early 2027. But make no mistake, this case marks a truly pivotal moment for how copyright law is going to apply to generative AI in Europe. The outcome will definitely be watched globally.
What's fascinating here, moving on a bit, is how these major regulatory shifts, the strategic plans, even these really thorny copyright issues, are also inspiring practical tools and innovations. Things that are reshaping the legal profession itself. It's not just about the rules changing, it's about the tools evolving too.
Indeed. And one such innovation that's getting a lot of traction is legal design. Particularly its focus on something called information architecture.
Legal design. Information architecture. Sounds a bit abstract.
It can sound that way, but it's actually very practical. It isn't just about making legal documents look pretty, though that can help. It's about fundamentally changing how legal information is structured, accessed, and used. The goal is to bridge that gap between complex law and real-world application, making legal services more efficient, less intimidating. Basically, the art of organizing content so it's clear, functional, easy to navigate, coherent, and genuinely user-friendly.
That sounds incredibly useful, honestly, especially with legal documents often being so dense. So do you have any little tips or tricks on how we can apply this legal design thinking in our daily activities, maybe even beyond just legal documents?
Absolutely. There are some simple things you can do when structuring any kind of text, really. Use a table of contents if it's long, use clear descriptive headings, keep paragraphs short and well-ordered, ideally just one main idea per block, and always include an introduction and conclusion to help guide the reader.
Simple but effective. What about existing documents? Can you retrofit them?
Definitely. If you're redesigning something, start by spotting where people get confused. Cut out repetition and redundancy mercilessly. Group similar sections together logically. Add headings, maybe use boxes or definitions for key terms, maybe even a short how to read this document guide. Another really powerful technique is information layering, sometimes called progressive disclosure.
Progressive disclosure.
Yeah. Start with the absolute essentials up front, then allow the user to go deeper if they need to. They give a short, simple introduction, followed by more detailed explanations later. You focus attention on what the user needs right now. You can use internal links, external links to appendices or FAQs for that extra detail.
Okay, I like that. Control the information flow. What about visually?
Visually, simple things help a lot. Add white space, let the text breathe. Use boxes, icons, or bullet points to highlight key information. Maintain visual consistency in fonts and formatting. And please, use bold and capitalization sparingly. Too much just looks like shouting and loses impact.
Good point. Any other practical tricks?
One I really like is card sorting, especially when designing something new. Write each topic or section heading on a sticky note, then physically arrange and rearrange them on a table or wall until you find the most logical flow. It helps you design the structure before you get bogged down in writing the actual words.
That card sorting tip is brilliant. I can totally see how that would work. And I can see how all this structure makes a huge difference. You mentioned before that users only read a tiny fraction of digital text.
Exactly. Various studies show users typically read only about 20–28% of the text on a digital page. They scan, they look for keywords. And the why behind applying legal design is crucial. Confusing, poorly structured content frustrates users. It increases errors, wastes time. But a well-structured document, legal or otherwise, guides the reader, orients them, empowers them to find what they need quickly. It saves time, boosts comprehension, reduces mistakes. It's not just about aesthetics. It's fundamentally about efficacy and usability.
That focus on clarity and accessibility seems like a really important guiding principle here, which actually raises an important question. How is this focus changing the wider legal data landscape? It feels like we might be on the cusp of a massive shakeup there, too.
We absolutely are. This brings us neatly to what some are calling the Great Legal Data Liberation. A really seismic shift happened recently when literally millions of U.S. court cases became freely available on Hugging Face.
Hugging Face, the big AI and machine learning platform.
That's the one of the world's largest. This single development profoundly challenges the traditional legal tech business models, many of which were built on charging premium fees for access to proprietary legal data, like court rulings. It fundamentally shifts the focus. It's moving away from simple data acquisition towards data intelligence, meaning the value isn't just in having the raw data anymore, it's in what you can do with it, the analysis, the insights.
So no more paying top dollar just to get your hands on raw court documents, potentially. Is this just a U.S. thing, or is it a global trend?
It's definitely creating a ripple effect globally. We're seeing similar initiatives emerging elsewhere. For instance, the source mentioned innovative developers in Italy working to democratize access to Italian jurisprudence. And beyond that, court systems themselves, worldwide, are increasingly providing direct API access to their decisions.
API access, so computers can just pull the data directly.
Exactly, which could potentially eliminate the need for those traditional intermediary data providers entirely in some cases. It's potentially a huge power shift in the legal information market.
So what does this all mean for the people actually using these tools? For in-house legal teams, for general counsel who are constantly trying to navigate legal tech procurement and figure out what tools to buy?
Well, for in-house legal teams, this presents some really significant strategic implications when they're buying legal tech. First, contract term evaluation becomes key. They need to look really closely at their existing contracts. Are there renegotiation clauses? Are they paying for data exclusivity that no longer exists? Are there performance benchmarks tied to data access that might now be irrelevant? Especially if you're paying premium prices for data that's suddenly becoming free or much cheaper elsewhere.
Good point. Check those old contracts. What else?
Second, value proposition reassessment. When looking at new tools or renewing old ones, the focus has to shift. It should be on the intelligence layers.
Intelligence layers.
Yeah, things like advanced natural language processing. How well does the tool understand and analyze the legal text? How good are its integration capabilities with other systems? What customization features does it offer? Does it have sophisticated analytical tools, predictive analytics, identifying trends in case law? The raw data itself is becoming commoditized. The real value now lies in the insights you could derive from that data.
Okay, so it's really about what the tools do with the data, not just that they have the data. Makes sense. So what about actually making procurement decisions now? Any recommendations?
Definitely. Third, procurement strategy recommendations. Teams should consider shorter contract terms, maybe 2-year agreements with annual reviews rather than locking in for 5 years. This maintains flexibility in a rapidly changing market. Explore performance-based pricing models, where costs are tied to measurable outcomes or value delivered, not just access. Consider a hybrid approach, maybe combining free, open-source data access tools with specialized commercial solutions for that high-value analysis layer. And finally, foster vendor diversity. Don't put all your eggs in one basket, especially now. It reduces dependency and encourages competition.
What does this mean for the vendors themselves, the legal tech companies?
Well, the new competitive landscape means we're likely to see more AI wrappers built around these newly free legal databases. Competition will intensify, which should hopefully drive innovation and also put downward pressure on prices, especially for basic legal research tools.
Yeah.
We'll probably see vendors specializing more, differentiating themselves based on superior user experience, better analytical capabilities, or niche expertise rather than just data access.
So ultimately, this is a good thing for the users, the legal teams.
It really should be. This is a significant strategic opportunity for in-house legal teams. It should lead to reduced research costs over time, access to enhanced capabilities through more advanced tools, faster innovation in the market, and better customization of tools to fit their specific needs. It's potentially a game changer for access to justice and overall legal efficiency.
Wow, what an incredible journey we've taken today through Europe's really complex AI landscape, from that groundbreaking regulation and the huge strategic plans, all the way to cutting-edge legal tech and those really thorny copyright challenges. We've really seen both sides of that AI coin, haven't we? The control side, focusing on trust, accountability, the high-risk stuff, and then that really ambitious growth side, aiming for digital sovereignty and innovation.
Indeed, it's a dynamic picture. And maybe to leave you, the listener, with a final thought, kind of tying together those themes of data and intelligence we just discussed. The data itself, the raw legal information, it may well be becoming free, or at least much more accessible. But that intelligence layer, the ability to extract meaning, predict trends, analyze risk, and genuinely inform decisions from that data and the strategic advantage it provides, well, that's going to be more valuable than ever before.
The data is free. The intelligence is priceless. Something to really mull over. Definitely consider how all these developments impact your own AI readiness, your organization's readiness, and how you plan to navigate this incredibly fast-moving landscape. The future of AI in Europe isn't just being built, it's being legally defined, strategically planned, and practically innovated right now as we speak.